Welcome to today's CCPL seminar. We are here to discuss evolving trends in criminal law and procedure, probably more accurate to say from a Nordic perspective. In fact, it is quite rare for us to have speakers from that part of the world, so it's a real treat today to welcome our guest, Professor Lene Wacher Lentz, who is a criminal law scholar from Aalborg University in Denmark. And she is here for the whole week. She's already been quite busy helping with contributing to a very interesting project on criminalizing surrogacy. But she has very kindly agreed to speak on not one, but two very interesting projects that she's been working on. The first one is on the increasing penalization or criminalization that she's noticed in Denmark and her country. And then secondly, she's going to be talking on very interesting developments in relation to digital evidence in her country. So please join me in welcoming Professor Lentz to our university. And we will take questions after each of the presentations.
Thank you very much. And thank you, Simon, for the opportunity for me to be here. I really appreciate it. I hope I have chosen two topics that are also relevant and could inspire you to do research into these fields of law. I hope the sound is okay when I'm talking like this. Great. Well, the overall title here is Evolving Trends in Criminal Law and Criminal Procedure, and I've chosen two subtopics that I'm involved in. The first is the development of a criminal code in a 40-plus years period of time. It was actually to investigate if we could clarify a punitive term in the Danish criminal law legislation. And after that, I think there will be a break, at least to just get some air and just a short break. And then we'll carry on with the criminal procedure in light of digital evidence, where we also see a development in recent times. Well, I included a bit information about Denmark to start with, and it's actually to elaborate a bit on the context for Danish law. We are quite a small country. You can see how I have caught us in a small circle on the big map. It's a small country with approximately 6 million inhabitants. We're part of the Nordic countries, also together with Norway and Sweden and Finland, Iceland. So we have some things in common. And of course, we're part of the EU that also put some influence on our legislation. Well, we are a kingdom, and this is our Queen Margrethe. Now it's a son, Frederik, who has taken over. We have some history in Denmark. Hans Christian Andersen, who wrote The Little Mermaid and The Ugly Duckling and all that. We have Kierkegaard as well, as a great philosopher. And I included also a poster for tourism in Copenhagen here. You can see it's a police officer making sure that this family of ducks can pass the road. And it was actually a true photo taken, I believe, once in the 60s. And now it's been for several years a poster for tourism in Copenhagen. And I think it's an old poster, but I think also it's actually a picture of how we see ourselves in Denmark as this tiny people who are nice and friendly and very cozy, and we place a lot of trust in our police officers. They are clever and friendly, and they protect us. So this is kind of a picture on how we see ourselves in our relationship with the police officers on a daily basis. Well, being a part of the Nordic countries, we have actually the same approach, or have for some years had the same approach to criminalization, that convictions should lead to socialization of and rehabilitation of the convicted people, that imprisonment in itself is not a target. We need to have some kind of purpose for the individual in our criminal system. So criminologists have been talking about Nordic exceptionalism as a humane approach to criminal law, that we have this intense focus on rehabilitation. And for several years, we have not been affected by the more tough on crime stance in these matters, that things and crimes should be punished harder. But over the years, as a criminal researcher and also as the criminologists I've been working together with, then they can tell somehow, we see more and more criminalization, more legislation being passed in this area, and several times a year, well, we really need to change the criminal code again. And sometimes you get the feeling it's because our politicians, they have noticed a specific case, a robbery, a homicide, and these things occur, we know, but each time they feel inspired to act with new legislation. And so we had this feeling for years that something was going on. And me, myself, being a researcher in criminal law, went together with one of my colleagues, a professor in criminal law, and we have two criminologists in our research group also. We wanted to kind of elaborate on this to get a clear picture of what has been happening. And our names is here, Birgit, Annette, and Kasper from Aalborg University, and we decided to investigate what have happened in the last 40 years in this area. And it was quite a big task when we began to research on this. Well, these are some of the headlines in Danish media in the recent years. In the top left, the politicians' tightening measures in the area of criminal law have overloaded the courts, a judicial system under pressure. The number of ineffective symbolic laws is increasing. The capacity in prisons and detention centers is rising to 105% this year. More creative solutions will be needed to accommodate all inmates. And also poor lawmaking, it's a Danish word, lovsjusk. So if you're going to learn one Danish word today, let this be it. Lovsjusk is really, you've really expressed that the law is rubbish. So these are some of the headlines, and we think that corresponded also very well with our feeling of increased activity in the field of criminal law. So our focus for our research was the Danish Criminal Code. It consists of a general part covering all the principles relevant here: legality, attempt, conspiracy, jurisdiction, limitation periods, and specific conditions for the punishment. And then, of course, we have the specific part with the criminal provision, because it's consisting of the most serious offenses: terrorism, homicide, violence, arson, robbery, etc., etc. And besides that, besides the criminal code, we also had a lot of supplementary legislation on specific topics such as drugs and weapons and traffic, the treatment of animals, and regulations for specific areas and industries, and so on. We chose to focus only on the criminal code and not all the supplementing laws, and I think we had a big job on our tasks, just focusing on the criminal code. Because we settled on this period from 1980 to 2022, because we believe that in the 80s it was the before period, because the criminologists, they're talking about a change perhaps during the 90s. And then we wanted the before that period to compare. And the first step we made was simply to see the activity before we decided how to code this development. We wanted to see a picture of the activity. So how many amending laws in this period of time of 40 years plus? And in each amending law, how many criminal provisions have been amended? So the number of amending laws to the criminal code and the total number of amended provisions. So that will give us a picture of the activity. And this is the picture here. And you can see in the right side of the slide that in the whole period we had 170 amendment laws. That's the black line in the picture, with a total of 911 amended provisions. That's the orange line in the picture. The criminal law, the criminal code is in total now 306 provisions. So it's quite a lot of amended provisions we had. I just need to address the two peaks because they are simply taking our focus. What happened in 2000, that is the biggest peak in the picture. It was a reform of simply one word in the criminal code, changing the word for imprisonment. Previously, we had a specific word for the imprisonment where very lenient conditions applied in comparison with a more strict way of being imprisoned, but it hasn't been a reality for several years. So just changing one word in several provisions gave us this peak in 2000, and there's nothing in it. It's not, there's no reality behind this. The other peak is in 2004, where we also had a significant number of amended provisions. There was a large revision of the penalty ranges that were carried out at the time. It affected a lot of provisions. In most cases, they were neutral changes, but there were some, more harsh sentences and more lenient sentences. But it's a picture of a lot going on in 2004 as a revision of penalty ranges. But as you can see, I think I should just, when we zoom in, the peaks are smaller in 2000 and 2004. But it's significant in the 80s. If you see in the 80s, there were years where we didn't even once amended the criminal code. In 83, in 84, in 88, in 91, there were no changes on the criminal code. Not once we felt inspired to change the criminal code. As a contrast, if you look in 2018, it was 16 times, 16 amended laws changed several provisions in the criminal code. And it's I should say it's the calendar year, not the parliamentary year 2018, but you should consider 16 times a lot, because each time a proposal for law is made, it is treated 3 times in our parliament, it's referred to a judicial committee, it is decided, it enters into force. So 16 times that you can't even wait to collect things and make perhaps 4 laws in that year of 2018. That indicates some kind of rush here. 16 times, that's quite a lot, 16 laws. And you can see when we zoom in also that when is this actually happen? Out of the 177 amending laws with the black line, 142 of these were passed after the year 2000. So that's actually the majority that's been happening in recent years. And also has of course, also an impact on the amended provisions that also the whole amount of 877 were passed after the year 2000. So it's an increased development after the year 2000 in this activity. But this picture gives us the initial counting of the activity, but we couldn't see what the amendments to all these provisions, what were they actually about? We had to think very carefully about how to dig into this and how to analyze it. But we were sure that we had to go into each of every of these 911 amended provisions to get the picture of what is going on. But just the activity, increased activity in this field. So we decided to make a code book to actually go through these 911 provisions that has been changed, these amendments. And this is our code book. Each amended provision, we would give 2 codes. We will code it for the criminal deed, that is to say the content of the criminal deed, and also the sentencing. And it's of course, it's very much relevant to Danish law and how we did our legislation. So it's not, you can't equal other society or jurisdictions to this. It has to be assessed very individually how it makes sense in each jurisdiction, how to measure it. But in relation to the criminal deed from each of these 911 amended provisions, we would categorize either what happened was a decriminalization, that would be a removal of a criminal deed. It could also be a limitation of the criminal deed, so to speak, a partial decriminalization. It could be new criminalization, establishment of a new criminal deed, or extension of the criminal deed as a partial new criminalization. For instance, extension of the criminal deed, that happens sometimes when the scope of an application were broadened. For example, we had a provision on sexual acts forbidden in relation to committing the deed to your own children. Then there were an amendment that this should also be permitted if you do it to your adopted children. So that's actually a broadening of the scope of application, where new potential victims were also part of the criminalization. Then we had the neutral category as well. That could be only modernization or something about the structure. Nothing really happened in relation to punitive or non-punitive. And then we had also a technical category if some changes were made, and it just as a consequence, we had to change other provisions as well, but it didn't actually say anything about the punitive or non-punitive. So that was the coding of the criminal deed. And then in relation to the framework for sentencing, we have some of the same categories as well. Decriminalization, that means a sanction is removed or annulled. The penalty range in the existing provision is being reduced. For instance, before you could be imprisoned for up to 2 years, and that might be changed to 1 year of imprisonment. We have new criminalization, that means a new sanction is established. And of course, also the penalty range in the existing provision is being increased. I will just save these two indications. And then of course, we have the neutral category and also the technical. There's a small error in the last sentence because it is copied from the coding of the criminal deed. So the last sentence should of course be without change of the framework for sentencing, not related to the criminal deed here. Well, to focus a bit on this indication of penalty reduction and indication of penalty increase, that was in fact a violation we saw when we elaborated on these each of these 911 changes in provisions. It was something that our legislators, an idea they had got at some point in time, that if they made a minor change in the wording of the provision, it was a complete non-important word that they changes, but it gave them an opportunity in the legislative work to indicate some level of sentencing here. So perhaps they changed in the wording of the provision the word "and" to "additionally," and then in a legislative work they can indicate what is the specific level of sentencing for this crime. And it was done, for instance, in relation to burglary in a private home. It was normally sanctioned with 30 days of imprisonment, and it was indicated in the legislative work that it was now to be punished with 40 days of imprisonment. And the wording of the provision was only changed with a word that didn't make any sense, but this was actually the purpose of it all, for the legislators to indicate in the proposal for law that we want this sentences. And we had the violation, of course, indication of penalty reduction in the legislative work, and also the indication of penalty increase in the legislative work. So, of course, this code book was meant for criminal provisions that are stated, if you do this and that, you can be punished with this and that kind of sentence. Then we were considering, should we try to code the general provisions of our criminal code also, the provisions on attempt and conspiracy, jurisdiction, etc. And we decided actually to include that part as well, but we did it in a very conservative way. So we, as a main rule, we coded it neutral unless we could see a significant aspect of punitivity or non-punitivity. I could give you an example, for instance, when our jurisdictions, our provisions or statutes on jurisdiction were amended, if they were broadened, so to speak, then more criminal deeds committed abroad could be prosecuted in Denmark. Well, that would lead to potential more criminal cases to be prosecuted in Denmark. And then we coded this as a punitive term. But we have written an article elaborating on all these methods, so I'll give you an indication of it was very complex. So we decided to code, but in a very conservative way, also the general provisions of the criminal code. And then we developed some general principles along the way that when coding these 911 changes, that we would be completely sure that we could see something punitive or non-punitive. Otherwise, we would code it as neutral. Because over the 40 years of legislation, a lot of different things happen. And sometimes it's very confusing. Is it more punitive because they're changing this word? That could speak for punitivity, but this word is perhaps the complete opposite. So if we one plus and one minus, we would code it neutral, and to make sure that our conclusions were that they really were significant. And we also developed the principle of a kind of holistic view to this, that to see through the strategies behind legislation, because sometimes, for instance, a whole chapter provision is changed and things move around. Subsection 4 is now subsection 2 to a different paragraph, and it's just what is going on here? And it's just a modernization, it's restructuring, it's a lot of things. But we will see, okay, bottom line, what is actually happening here? Can we see something more punitive or less punitive? Otherwise, most of it would be neutral. It's just a modernization language structure. Yeah, but the coding was really a big task. It took us a year and a half with our student workers. We had a lot of discussions how to code things, and we had an alert list that we would come up with a subject and meet instantly to solve this coding issue. So it was a big work. We have written a Danish article about our method and our results, and we're working on an English article also with the same focus. Well, that was the method, and I will move on to some of the results. Development in relation to the criminal deed, the instances where we had some decriminalization or partial decriminalization. You can see that didn't happen very often over the 42 years. 8 times we had decriminalizations. That would mean that a criminal deed is removed. And 4 times we had partial decriminalizations where the scope of a provision is narrowed. So this is not very often that happens. On the contrary, when it relates to new criminalization or partial new criminalization, it's the complete opposite, as you can see here. 56 times it happens that we have new criminalization, new criminal deeds. That's the orange line in the picture. And 43 of these were passed after the year 2000. And 120 times we experienced partial new criminalizations. That's the blue line in the picture. And 100 of these were passed after the year 2000. So that's a significant development in the criminalization and partial new criminalization. And also we began to focus on the year 2000 as a year where after that we can see a new development. There's a before and a after the year 2000. In relation to the framework for sentencing, that will mean the coding for decriminalization the penalty range reduced, or this specific variation of the indication in the legislative work of a penalty reduction. And in this period, we had 9 times what we call decriminalization. That means a way of sentencing that is removed. And 40 times we experienced the penalty range in an existing provision is reduced. That's the blue line. And 0 times we experienced the penalty reduction indicated in the legislative work. So that's a variety we actually didn't see. The green one is in the lowest area throughout the 40 years period. Well, that's also in the contrast to the development in regards to the new criminalization, the penalty range increased, or the indication of penalty increase. So there's a whole new picture here. We experienced in the whole period 56 times new criminalizations, that's the orange line, of which 49 were passed after the year 2000, and of which 27 were passed within the last decade. We experienced 187 times where the penalty range in an existing provision was increased. That's a blue line. Of these, 170 were passed after the year 2000, and of which 121 were passed within the last decade. And for this, a specific variation where it's in the legislative work indicated what kind of penalty the legislators wanted, we experienced this 25 times, of which 23 were passed after the year 2000, and of which 22 were passed within the last decade. So again, we can see the year 2000 is actually something is happening here, but also within the last decade, there's really been a new activity in relation to criminalization. So this is our pictures. I've collected some of our results and conclusions here. Over this period of 42 plus years, we have experienced in Denmark a punitive turn, and we believe the crucial year to be the year 2000. That's where something changes. More criminal deeds are punishable, the penalty ranges have increased, and this is supported by the new phenomenon indication of penalty increase, particularly observed in the last decade. And the indication of penalty reduction, we did never see that occur in our findings. Overall, we believe the punitive turn to be escalating in the last decade. And very interesting, we saw a report from a committee established by the Ministry of Justice last year that went through all the court practice and all these amendments to the criminal code, and their conclusion was that the courts generally follow the legislator's guidelines on sentencing. So when a penalty range is increased, it is actually used. When the legislators indicate some kind of sentencing level, they comply with these sentencing levels. So it has an impact in specific cases what they are changing in our criminal code. But it is a big discussion because the criminal code should also be dynamic and reflect modern threats to society. So of course, during a period of 40 years, it will be necessary to change the criminal code to cover new criminal deeds that we think should be criminalized, perhaps in relation to terrorism and cybercrime, and also the new understanding of gender and sexual relations will be reflected in a criminal code, and that was actually one of the chapters that was amended the most. The chapter about sexual offenses that was really over the 40 years constantly in focus. So of course, our criminal code should be dynamic and reflect this, but we believe that the picture is also showing that we're in a hurry all the time to respond with criminalization to whatever threats to society, small or bigger threats to society. And we believe that we have made a picture for us to qualify a debate on the purpose of criminalization. that this feeling we had that are we using criminalization too much? What is happening? Why again changing the criminal code? That now we can discuss this and see what is the end line actually for this. Do we want lifetime for all criminal deeds? Where are we going? And we have gained some attention on our research project. Actually, we were invited to speak in the judicial committee in the Danish Parliament. We were also invited to an informal talk with the head of the Ministry of Justice. So we are gaining some attention back in Denmark because of this. And what we're doing right now, of course, as I said, we're working on an English article where we develop on our method and our results. We are also working on a Danish article on the legislative process, because it's also our feeling that the legislative process is more in speed now than before. It's really a rush. So measuring different points in this process can give us an indication on is this faster now than before? Of course, there's something good about being fast, and also if more things are digitalized in the legislative process, we don't have to wait for a physical letter to arrive in the mailbox. That's no matter how you see it, it's positive that we're not delayed. But that's our next article about how fast it is, and then we will also see a significant result in the speed over the 40 years period of time. But what we're doing right now is also to develop a comparative Nordic study together with Norway, Sweden, and Finland, because they are experiencing the same development. They have also the feeling that this is a development from Nordic exceptionalism to a more tough on crime stance. And we can also see that the Nordic countries inspire each other when they experience, for instance, in Sweden, some problems related to gangs and shooting in the streets. Well, they tend to copy the Danish legislation. So they keep looking at Danish legislation and copy the provisions that they feel they have a need for. So this will be very, very interesting to see in connection to the other Nordic countries. How are we moving forward? Yeah, thank you.
Thank you very much for that, Nina. Very fascinating. So we've got some time for Q&A. Maybe I can just kick off with some questions on methodology, because I think that struck me as one of the very interesting aspects of your research. I've never seen anything done quite like this. So when you wanted to do the coding, was there any reference point or any reference research that you found that had attempted to try to look at this aspect of punitiveness in criminal codes? Is really what we're talking about. Had anyone tried to do that before?
We didn't find any literature on this, because when you are measuring punitivity, and this is according to a criminologist in the research group, very often you see how many sanctions for this and this, how much imprisonment for this and this. But this coding of legislation, that was, I believe it's a new thing. We couldn't find any examples on this, and we developed the code in relation to how it made sense according to the Danish legislation.
And of course, it would probably involve some degree of evaluation, yeah, which might be debatable, I suppose. So your criteria would have to be quite important. And I hear that you said you had already written something in Danish on the methodology, yeah, but you will translate it into English. Okay.
We're also writing an English article where we develop our methods and our results. Yeah.
Yeah, so I think that would be valuable. Yeah, yeah. The other question I wanted to ask you is about sort of where you're going to take this research forwards, because it seems to me it's pretty much just at this point, anyways, a kind of a desktop kind of work, looking at the laws and how they've evolved and tracking them, not really digging into the questions of why or how. So whether you would want to explore that, of course, I mean, the comparative exercise doesn't necessarily go into the whys or the hows, So whether you would, expand your research methods to include maybe interviews and maybe looking at other sources of data that try to track the causal connections.
Yes, we have been focusing on the data material, the number to see the picture, but and I have let out our prioritization of the articles to come. But of course, we're well aware that we have a quite unique data set here for elaborating on what is specifically going on, because we have all kinds of possibilities. For instance, I mentioned the chapter on sexual offenses, what is actually going on through the 40 years period of time. So we can measure on specific topics, what is happening to youth, for instance, the regulation related to the children and young people. So we can make all kinds of, dig into that data material and dig out and elaborate on that. And that will, of course, be with some research on the purpose of this legislation, also what is the need for this particular development in this area. So we've got a lot of different possibilities for elaborating on our data material, but collecting it was the biggest part, I think. Yeah.
Good. Okay, great. Other questions, Daniel?
Thanks for your presentation. So it's clear that you're focusing on the criminal code, right, rather than which of these offences are enforced in practice and what the quantum of sentences. But another question on methodology might be all of the expansions or contractions in penalties and all of the new offences or decriminalizations, on the other hand, are scored the same way, right? So whether let's say a fine is increased by 1 kroner, that's the currency, right? 1 kroner or 100,000 kroners, it's also scored the same way.
Yeah.
Or whether a new offence is created that has a maximum of 6 months imprisonment versus 60 years imprisonment is scored the same way. Yeah. So at the moment, the coding is kind of two-dimensional in that sense rather than three-dimensional. How would your findings look if you took into account the quantum in terms of the amount of difference and not just the fact that there are differences over time?
I think that would be one of the next steps to evaluate more in quality of the legislation and what is amended. But we have several possibilities for statistics, and also been research in Denmark about the amount of sentencing, how many people in prison, what for robbery, how is the specific sentencing developing. So we have actually some statistical information to support this. But of course, as you say, we haven't got the connection, so to speak, for each amendment. What is that causing in sentencing? But that that might be developed. But for now, it's I think we have a big data set and we can go all kinds of ways. Yeah. But thank you for your comment.
Other comments or questions? Yes.
Professor Lentz, migration is a very big problem to all European countries, including in Nordic countries in Denmark, Norway, Sweden, and Finland. Migrations from Middle East, especially those Muslims or those people who have different religions, have different religions. So their living style is quite different from the people of Nordic, from Denmark, from Finland, from whatever. So criminology, in other ways, it has its impact. That means different people from different countries have different ideas about the country they are migrating to. That means something which allow them in their own country, but prohibit in the Nordic countries. So is there any proper way to educate those migrant people, the proper way, I mean, the proper way to educate them to adopt to the law of those countries they migrate into, those Nordic countries they migrated into, so that they can change their mind about the law in their migrant countries? Thank you, Professor.
Okay.
Okay.
It's not directly related to your research. I don't know if you want to answer that.
Yeah. It's just a note on migration aspects of this, because in Danish criminal code, we don't have a provision about deportation and extradition of Danish jurisdiction and all that. That's a separate law, actually. And we have been recommended to also do that part, code that part of our legislation, because I believe we can see a significant increase in deportation rules in Denmark, and also convictions where people are expelled from Danish territory. But that's an issue that it's a big task to code that as well. Yeah. But in relation to EU, it's one big area now where people can cross borders, and they have to familiarize themselves with the legislation in other jurisdictions, and might sometimes surprise them what is forbidden in Denmark, at least, and the sentencing. Yeah.
Okay. Yes, please. Do you want to press the button? Yeah, good.
Yes, thank you so much. So I had a question. It's less about methodology, about the results. It's more about embedding them in Danish society, in Danish political discourse. Have you also noticed on the side a sort of parallel emergence of penal populism, punitive populism, in which you could embed these trends since the 2000s that would move away from exceptionalism? I know it's also in the further research, but you as a Danish citizen, or does it emerge from the political side, the legislator, or is it something that has emerged from the people?
Yeah, I think our criminologists in the group, they have written something about this, because in Nordic literature, it's developed that there's a change in the 90s from this Nordic exceptionalism to a more punitive term. So it's described in criminology and in literature. And I don't know if I'm not perhaps the right person to say what's causing this development, but we can see that it's actually a routine response to a lot of the stories that occur in media, that you need as a politician to show some kind of guidance to the population, and there might be a reflection in that as a citizen, that we also expect them to do it, and we expect them to take a tough stance on whatever makes us feel unsafe. So it might be something corresponding with each other. They feel obliged and inspired to propose new legislation and show us they got this handled, and we also expect them to do this to make us feel comfortable. There's a significant criminal literature in these movements. Yeah, but a great question. Thank you.
Yes, Aaron.
Thank you very much for the very exciting, insightful presentation. I certainly think that is a very meaningful project to measure the punitiveness, how it changed. But I also wonder that whether all aspects of punitiveness can be measured by this way of studies. And I also think that sometimes, for example, in Hong Kong example, sentences or youth sentencing are getting much tougher without necessarily having related to legislative changes. For example, the judicial attitude might change towards more punitive or more lenient throughout the course of normal judicial development. So I wonder that from a legal academic or practitioner's view in Denmark, do they is their feeling, or ordinary citizens' views, is their feelings in line with your research that generally the criminal law is going more punitive in Denmark, or is the average length of custody or the time people spend in prison are also generally increasing in
yeah.
So,
but there was some headlines from the Danish media that the prisons are overcrowded. We are thinking about imprisonment, a prison in Kosovo for some of our prisoners. And the court system is overloaded. I think if you have a 2-day case now, and in most cities you can only have it booked for court proceedings in a year or 2, or sometimes 3 years from now. So it's the judicial system under pressure. And also with this report from last year from a committee under the Ministry of Justice, that the courts are using these new guidelines in sentencing that they are using the maximum limit. Sometimes they are using these indication of penalty increase. So it's always difficult as a researcher to measure everything, but we try to measure what was the instant feeling from our side, and then we can see afterwards it really reflects very well with what else is shown in relation to our court system at the moment.
And Lena, I think you were saying over lunch that you're increasingly seeing the introduction of minimum sentences. Yeah.
Yes, and that's also something new, and we also developed that in our methods and results articles, that previously we had penalty ranges from a fine to imprisonment to 6 years. And at some point, I think it was in relation to a gun offense, that a minimum penalty is introduced. So the possession of a weapon in the public space that must be punished with at least 1 year in imprisonment. And I think already the year after or 2 years after that was the minimum sentence was increased to 2 years. And also in other provisions, a minimum sanctioning is introduced. So in many ways we see this punitivity, and it's also restricting the courts in how they decide the sentences in specific cases.
Okay. Good. Unless anyone has any further questions or comments, shall we move on? Dan, go ahead.
Yeah. Yeah. Yes. But no, of course not, because with this amendment, there's a political debate where the politicians say we really need an increase in imprisonment for this and that, and then there are arguments. So of course we have made lots of slides from the 40 years with headlines where the politicians have their messages out. But this is it's more from the practitioner's point of view, this, the capacity in prisons, the judicial system, the court proceedings being booked and all that, overloaded the courts. It's just a process that actually supported our desire to go into this and just to see what is actually happening. Yeah.
It would be an interesting study to do a parallel systematic study of these media reports or statements by politicians over the same time period to see if you see the same trend, and then you have correlation, but maybe even suggestion of causation. Yeah.
Well, that would be for criminology, so language researchers to do that. The criminologist we have in our group, Casper. He's doing a research into the way some of our provisions in relation to sexual offences are being handled in the parliament, because for some of these provisions there's a very moral inclined to regulate and increase penalty, and some of the talking in the parliament about this is significant. For instance, Casper, he has noticed several times in the amendment of this chapter that the politicians are saying, here we cannot use the human rights courts, we cannot use anything, we have to feel the desire in our hearts to protect the children. So yeah, sometimes in the way we discuss things, there's also a significant contribution to this research, and that's just to mention one of the parts of areas he's engaged with at the moment, but we have a lot of things to do with this area.
Okay, shall we shift gears and move to part 2? Okay, well, thank you very much for part 1.
I really like that Max is handling this for me.
Okay.
Thank you, Max. Thank you. Well, this is sort of my own topic because the punitive research is I'm part of a group of 4, but this is kind of my own little child, the criminal procedure in light of digital evidence. Because I have a background as a prosecutor. I was a prosecutor for 10 years before I wrote my PhD. And the final section of the police that I was a part of was handling IT, cybercrime, that is in English, of course, cybercrime and digital procedure at the police department. And very often the police officers came and asked me, well, do these fake profiles, we can do this, should we do this? And I was just always looking at the regulation as in, we don't have any statutes about this. I'm not completely sure if it's legal, and all these challenges all the time. And the police officers were waiting for me to say yes or no. And I feel like my ethics in play all the time, and I could really get in trouble if I said something wrong. And that's because Danish criminal procedure in relation to digital investigation is very much a gray zone. So when I shifted to the academia and I started my PhD, it was exactly what I did, a PhD in the framework for the police carrying out investigation, secret investigation on the internet. So that was a lot about hacking servers and playing secret agents on the platforms, the social media platforms and all that. So that was kind of my interest and still is. But I think this is an area in a very significant development is also occurring here, both in what is challenging the investigation, but also we see a lot of initiatives from the EU that we are binded about and legislation in relation to directives from EU. Well, so if I should pick something we could talk about today, that was these 4 points on my agenda. We actually had a case back in 2019, and it's still affecting the Danish digital procedure. It was about our historical call data records, that there was a big scandal, we call it, or at least a neutral word, a Danish wake-up call, that we have an increased awareness about our call data records and the reliability on digital evidence in general. And that scandal led us to the establishment of the Danish Independent Evidence Oversight Board back in 2022. So that we touch upon briefly also, and then I will finish with the new challenges as I see them from these encrypted platforms, Encrochat and Sky ECC, and there are plenty others where the communication platform seem to appeal very much to criminals because they can communicate without interference, without registration of any data. And then I will finish with some perspectives on fair trial. But with the Danish scandal, I can call it a scandal, about our historical call data records. The context for this was that according to Danish law, the Danish service providers are obliged to register our call data. So that will be data related to who is calling who, the date and the time, and which cell tower used. And perhaps I should mention that in Denmark, our mobile phone communication is handled through cell towers in the landscape. So yeah, so that's the IT part of it. Well, the call data also relates to internet access. That will be user information and the IP address used for the internet access. So it's all registration of traffic data, not any registration of content of the communication. And the data is kept at the service providers, and only if the police are carrying out an investigation and they feel the need to have this data, they can go to court and have an order, and then the service providers will be obliged to hand it out. So that's actually the mechanism here. When it was discovered in Denmark in 2019 that we have some significant errors in these historical call data records, it was established that these errors related to the period 2010 to 2019. So it's quite a long time that we have had this going on. And it led to a review of several criminal cases, that is to say convictions. And the first decision was to review 10,000 criminal convictions, and they stopped after 5,000 cases. And of course, the review of these cases were to see if there has been any miscarriages of justice. And it was concluded after this review that the flaws in call data records did not have the decisive influence on the judgment. So actually, they stated that there had been no miscarriage of justice as a result of this. And then you might consider what is the value of these call data records in a criminal case. Well, they might tell you who did the suspect communicate with, but they don't tell you the content of the communication. And the call data records, they might indicate from the cell towers used where was the mobile phone situated at the time of the communication, not what the suspect was doing there. So call data records as evidence is very much related to indications, and these call data records might be very important in the initial phases of an investigation because they can lead to more intrusive methods, wiretapping, search and seizure. But in itself, it's much more just indications. So, of course, when they reviewed the 5,000 criminal cases, it's fair to say that I believe that the call data records did not have this decisive influence on the judgments. So luckily, no miscarriage of justice, but even so, we should learn from this scandal and what we can say about digital evidence after that. I wrote an article together with Lene Wacher Lentz, who is a police officer, and she did her PhD about the police officers investigating cybercrime in digital surroundings. She's very much an expert on these cognitive factors. How do we choose and how do we consider digital matters? The title of our article is "The Use of Historical Call Data Records as Evidence in the Criminal Justice System, Lessons Learned from the Danish Telecom Scandal." And in this article, I'll elaborate on all the details from this scandal. What is actually the technical part of it? Was it the outcome? And then Nina is applying her competences in relation to all these cognitive factors when digital evidence is involved. Well, this is the chain of custody for call data records. It's the whole chain. You can see my mobile phone in the left corner in the bottom of this picture. And then you can see one of our cell towers in the landscape. So my phone will always communicate with a cell tower for communication. And of course, the data from the call data will be within the service providers to record them and keep them for a certain period of time. Then we have the telecenter. That was a part of the Danish National Police who are handling the communication between the service providers and the police units around the country. So the requiring police unit, that is the unit within the police who are carrying out an investigation and who believes that now we need some call data records. Let's see if that brings us any further in this investigation. So actually, it will start with the police unit asking the telecenter, could you please make sure we get the call data records for this specific period of time. And then the service providers will hand them over to the telecenter. And of course, after the investigation, there will be an indictment, there will be a prosecution, and eventually the case will go to court. So this is actually, the procedure of call data records, where they come from when they end up in court in the final instance. Well, I have indicated where were the errors and uncertainties. It was in a software process that the telecenter applied. That was the biggest issue here. Call data records, that is mainly spreadsheets. at what time did the communication happen, who called who, and which cell tower has been used. And there were some of these rows and some of this data missing in the spreadsheet. So there were holes in the data material. And to a minor extent, there were errors in the data. So it was changed a bit, but it was not that important. This was discovered by a police unit that was carrying out an investigation of a particularly serious crime in Denmark. It was a killing of a young girl at 17. She was kidnapped and killed. And the police investigating this case, they discovered that this called as a records, they were missing several rows. It didn't make sense, and they couldn't recreate it. And I believe in the years before that, there has been some kind of warnings about something missing, but it has never been systematically recognized. But it was in this case, and that led to it all, that all this was discovered. And you might ask, why do they have this software process in the telecenter? That is because the service providers are obliged to keep our call data records and keep them in place if the police are going to use it. But they're not obliged to keep them in a certain format. So they keep it in all kinds of formats. And I think in relation to this investigation of this scandal afterwards, I think around 30 different formats were discovered in relation to how to mention a date and a time. So you can see if they ask the service providers for call data records, they come in all kinds of formats. So the telecenter, they decided it would be very nice for the requiring police unit to have a uniform format. So it looks nice. They have the overview of it all in the same document. Because the service providers, they might, if they should support the complete data material, there might be several service providers involved in covering this particular area and this particular period of time. So the telecenter, they had this software process where all the call data records they received from the service provider, they put it in the software process, and then it came out on the other side as a very fine document in a uniform format. And also what has happened here is that, of course, you can believe that with this police unit carrying out some kind of secret or important investigation, they're very impatient. When can we have the call data records? When can we have it? They're constantly asking. And in order to just be of service, the telecenter, they had applied a sort of timer function. So that when the service providers, they started transferring the data to the telecenter, they would start to forward the data to the requiring police unit. Then they applied a timer function that after an hour, it should be sent to the requiring police unit. So actually a timer function within this software process was the big culprit here, that it actually disturbed the software process. So data was transferred to the police unit without completion of data. Some data were missing because the timer function stopped the transference from the service providers and started sending. So before receiving all, it started sending to the police requiring unit. And that was the cause for these loss of data and rows. So actually it was just a way of being nice, a way of being speedy and comply with what they wanted. They invented this timer function, but it really disturbed the data, the quality of data. And in the middle of all this, because the software processor and this timer function were really the big issue, but it was also discovered that the data provided from the service providers were not accurate at all. As I mentioned, the uniform formats, that's one insecurity or one uncertainty, but it showed that also these cell towers, their positions were not accurate. Actually, the service providers, they're obliged to report to one of our ministries that where are these towers situated in the Danish landscape. But they haven't been updated, this information. And also from one of these towers, you can actually part it in different parts and remove some of it to another one other area and use it on a different tower. And this has not been registered at all. So these tower positions were not accurate, and they have both a GPS coordinate and an address, that is to say, a road in a town, physical address, and that was not corresponding with each other either. So all kinds of uncertainties and errors in relation to where were these towers actually situated. That came out also as part of this. Well, we have to know everything now, and that was a shocking experience also to know that these tower positions were not accurate. The last thing is that when you use call data records as evidence, there are many, many built-in uncertainties. And this has been a very known factor for several years abroad, but not in Denmark apparently, that my mobile phone won't always choose the tower for communication and the tower that is closest to me. And that can be due to all kinds of reasons. For instance, the landscape. In Denmark, we don't have much, that many mountains. We have small hills. But for instance, in big cities, big buildings made of concrete, that might disturb this traffic, this mobile phone communication. So my phone will not pick the nearest tower, it will jump to another one. That's a built-in uncertainty that do that. And also, let's say the nearest tower is overloaded with communication, or it's out of function. Well, my phone can pick another tower several kilometers away. So my phone would not always pick the nearest tower, and that was a completely new discovery through all of this. I remember, and that's old times now, but before 2015, when I was a prosecutor, we read out aloud in court these spreadsheets saying, for instance, in the interrogation of a suspect, well, we've got these call data records. It says that your mobile phone was in this area at that time. Well, you're saying another thing, implying that people are lying, right? And being a prosecutor with that way of handling call data records now, with the knowledge I have now, it's devastating because there's so much else to call data records. Back then, we didn't even know that the data had been through a software process. We thought it came directly from the service providers, these spreadsheets. So the software process and all these built-in uncertainties and the raw data flawed and all that, that was a completely new reality to us. Well, this is a part of Nena's conclusions, and you can see them developed in our article. But we have to look at different aspects to learn from this experience of all these call data records being full of errors and uncertainties. And one of the aspects relates to competence and responsibility, that actually we should consider this as a chain of custody, that we should really keep a focus on the originality and integrity of the evidence throughout the process, from the registration with the service providers and whatever happens to the data along the way in this process. And also to make sure that expertise unit holds responsibility and ensures quality assurance, not passing it off to subsequent stages. So what we could sense from this system is that the service providers had the impression, well, we're just handing out what we've got. We're not the police units. They can check for themselves. And the telecenter is just saying, well, we just got this from the service providers. It must be okay. We got this from the ones registering and taking care of this information. And then we'll pass it to the police units. They'll know what to do with it. And the police units, they will say, well, we got this from the service providers and the telecenter. They know what they're doing. They're the experts. We cannot check what's been measured and registered within a cell tower. And of course, we can't check anything. We'll just provide it for the prosecution. You know, at later stages, they have less and less expertise on the uncertainties in call data records. But everybody's sort of, I'm just delivering. Well, I'm just receiving. And nobody really takes the responsibility in checking who's checking this, and it's making sure it's accurate. And also, it's evident that we have some cognitive factors in place that are also disturbing this, that we in general have perhaps too much trust in expertise and quality. And well, that could also explain why these early warnings of errors in data were seen as isolated incidents, and there were no alarm and no action because before we had this very serious case that was investigated, and they could see, well, this is a huge problem. We don't have the complete data material. And we tend to have bias in a snowball effect, that if you have errors and bias and uncertainties on individual stages, and you have overconfidence to experts, you don't check, these things accumulate over time. So if data is flawed from the beginning, you add more error and more uncertainty, and you present it in court without the relevant reservations, well, it's not reliable evidence any longer. And also, it can lead to more intensive interrogation of the suspect. If you say, well, this call data record says this, and you say another thing, well, then the suspect is not reliable. It's a lack of credibility will influence the rest of the investigation, and we will perhaps tend to interpret all the other evidence in light of the suspect's lack of credibility. So things add up. At each level, another layer is added to the snowball, and it's just getting bigger. And this led to this called as a record scandal, led to a lot of initiatives. You can read about them in our article. That we have to present guidelines in court, and every stage in this chain of custody has to make some quality assessments. A lot of things that happened. But one of the things that happened is the establishment of this Danish Independent Evidence Oversight Board. And it's quite unique, both in the Nordic countries and the European countries, that we have this kind of evidence oversight board. But it's directly linked to the scandal with our historical call data records that I just explained. It's settled in our Danish Administration of Justice Act as a board that supervises the handling of technical evidence by the police and the prosecution. So that the focus for the board is to supervise quality and integrity of the evidence. They're not supposed to, or they cannot supervise the legality. That is understood as the legal conditions for obtaining the evidence. That is for the courts and the prosecution. The legality is not the issue here. And also aspects related to data protection, you know, the GDPR as we have in Europe, that is also a matter of legality and not for this board to be preoccupied by. It's not a board that is involved in individual cases. It's not supervision. It's not that individual cases has to be presented for the board, but they pick out a certain type of evidence and make a thorough supervision of it. So they choose a kind of technical evidence and make a general supervision of it. And this is where they have the focus on the entire criminal case chain. They have to make sure that sufficient and relevant procedures and guidelines have been established, that these procedures and guidelines are followed, that standard statements, police reports, etc., describe reservations and uncertainties that are generally associated with this type of evidence, that it is ensured that information about uncertainties and reservations is included in the criminal cases and presented openly during the court proceedings, and also to identify whether there are systemic errors in the handling of evidence. They will report and they will come with their recommendations. So you can actually see the whole background of the scandal from the call data records reflected in this procedure here, that it was all the things that lacked in the call data records scandal that they are ensuring now. And they have, of course, they had some time to settle and make some procedures, how to move forward. And they were occupied in the aftermath of our call data records scandal. And as the first evidence to make this supervision for, they have picked DNA actually. And they are perhaps this year, this this autumn, they're coming with a conclusion, a report, and some recommendations about DNA. So that's quite interesting to follow the establishment of this board and how it can inspire to keep competences in place and in quality assessment in all this chain of custody for digital evidence. So we don't tend to see it as a black box just coming out of something coming out of a black box that we just have to rely on. We have to keep constantly be skeptical and put the right questions in place. So that's a specific Danish invention, this Oversight board. And then I will move on to some of the new challenges as I see from encrypted platforms. And we have experienced in recent years some big raids towards some of these platforms. Encrochat that has led to a lot of criminal cases in Denmark, and also Sky ECC. They were attacked by international police authorities in a joint raid, and they were closed down. So that will be my focus before I conclude on this perspectives on fair trial. Well, we have been talking about traditional communication in relation to court data records, but it's a system we know and that has been in place for several years. That communication through the Danish service providers, that happens through Danish law, according to Danish law. They have, to a certain extent, the obligation to register our traffic data and our user identity, and they comply to Danish law. So the system is the police are carrying out an investigation. They go to court to have an order permitting them to interfere in specific communication related to a certain crime or a certain suspect. And this court order is presented to the service providers, and they're obliged to assist, and they do so. So this is a system completely known in place, and it works. Well, these encrypted platforms have emerged because the criminals, they want somewhere they can communicate completely in privacy. So they are communicated through these encrypted platforms. We don't always know where these platforms are situated. Where are the servers exactly? Because where the servers are is actually related to the question of jurisdiction. Which law does these encrypted platforms have to comply with? When they communicate on these encrypted platforms, they can rest anonymous. No user data is registered. They can communicate through this encrypted solution, and the encrypted platforms are not keeping any data in storage. So the whole infrastructure here is built so the platforms don't keep anything. So when the police comes with a court order, they have nothing to deliver. Actually, we haven't got anything. So of course they cannot, but of course they would not comply with court orders on this matter. I will use Encrochat as an example. It was a special Android phone with a lot of attributions in related to this, anonymous users, encrypted communication. And I have heard that if you had an Encrochat phone and you are suddenly almost arrested by the police, you can just swipe on the front page and all data on the phone were deleted. So there were, of course, some features related to these phones that was very interesting for criminal individuals to communicate by. At the time Encrochat was closed down, the platform had approximately 60,000 users. It was the French police that discovered that the Encrochat servers were situated in France. A French judge permitted the French police to hack the platform and carry out a surveillance of the platform for 1 or 2 months. Through this surveillance, French police succeeded in forwarding an update to the Encrochat phone. So actually this update reached all 60,000 users on each individual phone. There was a bug from the French police, so they could carry out this investigation, this surveillance. Well, it was a big success for the Encrochat from a police perspective, and I think the Europol and Eurojust, they were coordinating this activity. They made several press releases on the benefits from this investigation. I think last summer I saw a press release that approximately 7,500 years of imprisonment have been sentenced for people based on Encrochat evidence. So it's a big success, according to law enforcement agencies. But from a legal part of perspective, there are two, well, divided into two perspectives that are very interesting here. First of all, how do this kind of interference with the whole platform, how does this correspond with our legal framework for criminal procedure and investigation? Actually, they are hacking a complete platform with 60,000 users. They keep it on surveillance for a period of time, and then they make this raid. All countries involved at the same time with the parallel arrests. At least in Denmark, and I don't think in many other countries, we don't have a legal framework covering a situation where you want to interfere with the whole communication platform. It has to be specific court ordered for in relation to certain deeds or certain criminals. So this activity that the French judge authorized, it was based on a presumption that all users are criminals. That might be discussed because there might be people who are just worried about privacy, journalists, lawyers, doctors, and perhaps some political non-violent groups in opposition somewhere. It was an international platform, you can use it everywhere. So not necessarily all users are criminals. And I think also there are some ethical considerations where you carry out an interference of this size, because the police are monitoring a lot of communications at the same time. And also they have the obligation to prevent crime and stop criminal deeds. So perhaps in one part of this investigation, they are monitoring a communication in relation to one certain deed. And well, if we should prevent this smuggling of drugs, well, we should stop it now. But if we stop it now, we kind of saying to all the users that we are holding this platform under surveillance. So what else is going on is ruined. So there might be a temptation to raise a bit, just to see what else occurs. And in this, there might be some ethical considerations in relation to what are you closing your eyes for, what are you letting pass without preventing, because you're actually waiting for something bigger to occur, something bigger that might be more valuable to prevent. So actually, well, you can argue if following the communication of the planning of two homicides, which homicide is the most important, which one are you waiting for? And actually, they should, from an ethical part of view, perhaps they should stop immediately and prevent this criminal deed from occurring. So there's some ethical considerations in this waiting and when to hit the raid. What I will elaborate a bit on here is when the Encrochat material is used as evidence in specific criminal cases, because the French authorities have not been very eager to give sufficient insight in technical details. They have almost been completely quiet about what they have been doing and how they had treated these chat communications. And of course, you can see that if they have any plan to hack other platforms, they might keep their methods hidden for now to be able to use it in the future. But from a fair trial perspective, you need to have this chain of custody in place as to know what exactly did the French police do to data, and how did they hack the platform, and what did they do to the data afterwards. And also to ensure that we have the whole context for the communication. It's chat bits, it's sentences, it's words that is used as evidence in criminal cases, but what are they actually talking about? So if you remove one sentence in this communication, that can be pretty crucial. The Danish Supreme Court had the opportunity to, in two terms, to make decisions on evidence from Encrochat. And this is what they generally said in both cases, that they would not exclude, in general, Encrochat evidence from Danish criminal cases. Well, perhaps we did not expect that either, that a general exclusion. It has to be assessed individually in each case. But the Supreme Court said that the French police made the interference in compliance with French law, and the only matter for Danish police is just to receive the data afterwards. So there's no perspective of criminal procedure here, because the Danish police are just receiving data. And then the Danish Supreme Court refers to a declaration made by the Danish police on Encrochat evidence. And the Supreme Court states that, well, in relation to reliability and this Encrochat evidence, the Danish police have made this general declaration, and we can be very confident about that. In this declaration, there's a lot of reservations, and I'm not completely confident about this declaration. I'll just show a bit from it. Basically, Danish police, they explain in this declaration on the Encrochat evidence that they received the data from the French police on a CD-ROM. It's these old discs. No additional information is submitted from the French police. They could just stop this. And in the declaration, the police, they mentioned how they sort the files in different inventories. There are some general points of attention in this declaration. It's stated from Danish police, when using Encrochat data in criminal cases, there are several potential sources of error and uncertainties that one should be aware of. Already in the data provided by the French authorities, there are several inherent uncertainties and sources of errors. And this is my favorite. It has not been specified how the data has been secured, and as a result, it cannot be excluded that the data may be completely or partially lost or distorted during the securing process. Well, as a lawyer, I tend not to disagree with our Supreme Court, but I'm not very confident with this declaration from the Danish police. I think it's a very general disclaimer. I think it could be seen as a denial of responsibility in this matter. It's just, yeah, we are providing the Encrochat data for specific cases, but how it's made, and we haven't checked any of this. We have got this declaration, and you can just use it as you want. So I think the lesson from the call data record scandal is that we have to check every single information to make sure we got the complete picture. Well, the result is that the Supreme Court states that the validation of Encrochat data is up to the courts in specific criminal cases to decide. And during the last few months, I've been working on a case that was a bit extraordinary for me. It was the Court of Appeals judgment from last year, with 7 people charged with offences related to the joint trade of amphetamines and hashish. And my point of concern was defendant Ricky. I can call him his real name because he has actually participated in the media in Denmark, where he just told his story to Danish journalists. He had this Encrochat phone, and he said, well, my Encrochat phone has also been used by others. It was around in my circle of friends. So it's quite expensive, this Encrochat phone. So when we made our phone calls to our mothers and our girlfriends, we used our own phones. But if we had some matters a bit more confident, we used, well, they could borrow my Encrochat phone. And Ricky had said that on this Encrochat phone, he only communicated about smoke. That's a word for hashish in these communications. And whatever other people were doing, some of his friends with the Encrochat phone, it was not his problem. He didn't know anything about it, but there were parallel communications going on from this Encrochat phone. Well, in the district court, Ricky was imprisoned to was sentenced to 12 years in prison for handling at least 15 kilos of amphetamines. Messages from Encrochat were used as evidence against him. That was changed in the Court of Appeal, only 4 years in prison. He was acquitted of most charges related to amphetamine, convicted for 2 acknowledged charges involving hashish. So what was the difference between the first instance and the appeals decision on the matter? The difference was that the more context from the Encrochat conversation were included in the court proceedings. Ruby's communication about smoke, hashish was now included. And parallel to Ruby's communication about hashish, it was established that other people were using the phone to communicate about amphetamines. And it was actually his defense lawyer who were reading these chats very closely, and he couldn't, make up what is going on here, because sometimes from the phone a question was made, and it was like it was not answered, and then another question, and this, how is the flow of a normal conversation? He was just a bit puzzled about that. So this defense lawyer, he demanded that he had access to a complete data material. And that was quite big, a lot of spreadsheets with a lot of material, chat material. And then he realized that all the chats related to hashish had not been included for the court proceedings. It had been held out of the material of the police reports. And only the communication about amphetamine was included. So that was actually the difference, and also not very reassuring, actually, that it's the defense lawyer who has to insisting on getting the complete material. I have been sitting at the police office in one of the neighboring cities in Denmark, going through this material, because I was very interested to know, was it the French police leaving out this hashish material, or was it the Danish police leaving out the hashish material? And actually, the hashish chat has been there from the beginning. It was in the material from the French police. It was somehow the Danish police that did not include it in the police reports. So that was quite disturbing. So that's an example of the important aspect of having the total chat context, and to make sure that the complete picture is made for the courts to decide. Well, that much, just a bit about human rights, and I'm done. Of course, Human Rights Convention, Article 6, it's adequate time and facilities for preparation of defense and to have a possibility to examine witness and material against you. And there are some decisions from the human rights courts in relation to this. These are some of the decisions that both prosecution and defense must be given the opportunity to acknowledge and comment on the observations. And also, even as you can see in the Khodorkovsky's case, that you have the right to challenge expert credibility also. And then the Sigurd Einarsson decision, that's an incident of police handling large amounts of data, and the defense has to be given some kind of insight into how are the police selecting data in this big amount of data.